good Hodesh, a Hodesh Tov. We are welcoming the new Hebrew month of Sivan. It's my birth month, actually. I was born on the 16th of June and the 16th of Sivan. This is a wonderful month. It has the energy of Shavuos in it on the 6th of Sivan. We'll be celebrating that Saturday night. 2-day holiday outside of Israel. We celebrate the greatest day in the history of the world, when God appeared to 2 million people and gave the Torah, gave the Bible into the world. How's everybody doing? Let's light up the darkness. In case you missed it, I was actually just on doing a live show an hour ago as part of the Light of the Infinite festival. I told 2 stories of Hasidic rabbis, 2 stories each featuring 2 Rebbes, 2 Hasidic Rebbes, and also connected to my trip to Ukraine, which I probably won't be making again this year. But if you'd like to hear that, you can find it on our page just earlier in the feed at Accidental Talmudist on Facebook. And also at the festival, lightofinfinite.com. All right. Who is with us today? Stephen in New Hampshire, Tom in Pennsylvania, Melissa in Great Neck, John in Maine, Bill in Missouri, Sharon in New Jersey, Franco in Trieste, Italy. Welcome, Franco. Elizabeth in Tucson, Bella in Florida, Karen in Northern California, Shandora in the Bronx, Paul in the Great Northwest, Guy in Ohio, Clarice in Mexico City. Bienvenida, Clarice. Gail in Northern California, Renee in Indiana, Sharon wishing everyone a Hodesh Tov, Rick in Chicagoland, and Sharon connecting with Clarice. Her family's in Mexico City. My family lived in DF, right? Distrito Federal. Mexico City is what they call it in Spanish. We lived there for 4 years, but that was some time ago. A wonderful city. Over there on the YouTube side, Yitzhak checking in from Kansas City. Welcome, welcome. Today's episode of AT Daily, sponsored by our own Jeannie S. I will say, maintain privacy for the healing of her husband, Michael. May Michael have a refuah shlema. May the merit of our learning today accrue to his healing. May we only hear good news, and we say amen. And Jeannie and Michael, may you and all your loved ones be showered in blessings. And thank you for enabling us to share more Torah with more people around the world. If you'd like to sponsor an episode of AT Daily, you can follow the donate button at accidentaltalmudist.org. And it is especially awesome if you become a monthly donor. It helps us regulate, the finances of our nonprofit. And we're so grateful to everybody who has already become a monthly donor. Okay, we are on Daf Pei Dalet. We're going to start on Pei Dalet, page 84, but today's Daf is Pei Hey, page 85, here in Tractate Yevamos, the 14th volume of the Talmud. We are in chapter 9, and tonight we'll be concluding Mishnah number 1. We ended our discussion yesterday with this question. We've talked a bunch of times about what happens when a priestess, now a priestess in the Jewish tradition is not a priestess who serves in the temple. Only male priests served in the temple. But when we talk about a kohanes, right, what we mean is the daughter of a priest. Now, she has special privileges and obligations having been born into a priestly family. So she's known as one of the daughters of Aaron, just like the priests are the sons of Aaron, Moses' brother. So she's held to a higher standard. She has to behave in a certain way. And the question that was asked is, must she marry a priest? No, she doesn't have to marry a priest. She can marry out of the priesthood and marry in Israel. And we know that the law is, while she's living in her father's house, she eats teruma, food consecrated only for the use of priests and their families. If she marries a Yisrael, right, a regular Jew who's not a priest from a priestly family, she can no longer eat teruma, but she can have a wonderful life with him. What about a chalal? Right, so a chalal is the offspring of a union that's prohibited for priests. So the Torah says that a regular priest cannot marry a divorced woman, and a high priest cannot even marry a widow. He may only marry a virgin. So what if they violated that? What if a regular priest married a divorcee and had a child by her? As the son of a priest, he's a Cohen, but he has flawed lineage because his father married a woman who's prohibited to him as a priest, and so that son may not serve in the temple. Now, can a priest's daughter marry a chalal? A chalal is not a mamzer, right? A mamzer, it's a very, very serious transgression that his parents committed. He's the offspring of either adultery or incest. And a mamzer cannot marry any Jew, basically. A halal can marry another Jew. He just can't serve in the temple. It's absolutely permitted for any Jewish woman to marry a priest of flawed lineage, a halal. But what about a priest's daughter? Can a priest's daughter marry a halal? That's the question we're examining now. Rav and Bar Nachman raised an objection against Rav's ruling from the following baraisa. Right? It seems that Rav Nachman said, yeah, he can marry, a priest's daughter can marry a halal. Rav and Bar Nachman is going to, Rav ruled that a priest's daughter may marry a halal. Rav and Bar Nachman is going to raise an objection against Rav's ruling from the following baraisa. The verse states about priests. They may not take a woman who is a harlot, a zona, or profaned, a chalala, right? So a chalala would be the female offspring of this prohibited union for a priest. So they may not take a woman who is a harlot or a halala. A priest may not marry such a woman. And the same verse says, they also may not take a woman divorced from her husband. Now, this repetition of they may not take, because it could have said they may not take a zana, a halala, or a divorcee. Since the verse says they may not take a zona or a halala, and they may not take a divorced woman, the sages will see that repetition, this extraneous phrase, they may not take, as a place to derive another teaching from the Torah. So this repetition of they may not take teaches us that the woman is also prohibited by means of the prohibition addressed to the man. Therefore, we can conclude that there is a prohibition for a daughter of a priest to marry a halal. Just as a priest cannot marry a halala, a daughter of a priest cannot marry a halal, according to Rav and Bar Nachman. Rava said, Rav and Bar Nachman's objection is not valid. All that the Baraisa teaches is that anywhere that a prohibition of sexual intercourse applies to him, meaning a man, the same prohibition applies to her, his female partner. And anywhere that a prohibition does not apply to him, the prohibition does not apply to her either. It does not, however, indicate that since it is prohibited for a priest to marry a halala, that it is also prohibited for the daughter of a priest to marry a halal. Right? So this idea that the verse equates a woman to a man, says Rav Steinsaltz, there is no difference between men and women with regard to punishments for negative prohibitions. If he is liable to lashes for committing a sexual act, and the woman he commits the sexual act with, she also is liable to lashes. And if he is exempt, then so is she. So that's how men and women are equated, that if the two of them engage in a forbidden intercourse, both are subject to the same punishment. But we don't learn from that that just as a male priest is prohibited to marry a halala, the daughter of a priest and a divorcee, for example, we don't learn out from that the daughter of a priest is prohibited to marry a halal, the male offspring of a priest and a divorcee, for example. So the Gemara asks, with regard to this baraisa, and is this matter derived from here? It is derived from a different statement that Rav Yehuda said that Rav said. As Rav Yehuda said that Rav said, and the school of Rabbi Yishmael similarly taught, the verse states, Numbers 5:6, when a man or a woman shall commit any sin that people commit. And the verse here equates a woman to a man with regard to all punishments of the Torah. Consequently, the laws of forbidden marriages apply equally to women and to men, right? If a couple engages in an incestuous marriage or an adulterous affair, both of them have committed a crime and both of them are subject to the same punishment. Consequently, the laws of forbidden marriages apply equally to women and men. Why then do we need to learn the same thing from the repetition here regarding priests? They may not take and they may not take. And the Gemara answers, if it was derived only from that verse, that men and women are equated in that other verse in the book of Numbers, if it was only derived from that verse, I would say that this principle is true of a prohibition that is equally applicable to all. But with regard to a prohibition that is not equally applicable to all Jews, such as the prohibitions pertaining to priests, this is not the case. Since these prohibitions only apply to priests, we might have thought that they do not extend to women. The verse therefore teaches us that the prohibition applies to women in the same manner as men. And that's why Rav Bar Nachman concludes that just as a male priest, a priest is prohibited to marry a chalal, a daughter of a priest is prohibited to marry a chalala. The Gemara asks, but there is the prohibition for priests to contract ritual impurity from a corpse, right? A priest cannot enter a cemetery. A priest cannot make himself tameh, even for a close family member, only for his parents, right? So priests generally, or for the mace mitzvah, right? If a corpse is found between cities and there's no one to bury it, for this stranger who died with no one to bury him, for that person, a priest, even a high priest, will touch the body and make themselves tameh, ritually impure. But generally, priests are prohibited to make themselves impure by coming into contact with a corpse, because they are sanctified and have to keep themselves at a higher standard of holiness, so they're always ready to serve in the temple. But does that apply to the daughters of Aaron? Does the daughter of a priest have to keep herself from becoming into contact with a corpse, and that she also is prohibited to become ritually impure through corpse tuma? No, it does not apply to women. So the Gemara asks, but there is the prohibition for priests to contract ritual impurity from a corpse, which is a prohibition that is not equally applicable to all, as only priests are bound by this prohibition. And the reason that this command applies only to male priests is that the Merciful One writes, speak to the priests, the sons of Aaron, and say to them, none shall defile himself. Leviticus 21:1. From which it is inferred, the sons of Aaron and not the daughters of Aaron. Therefore, were it not for this specific derivation, I would say that women from priestly families are also obligated to avoid becoming ritually impure. What is the reason for this? Is it not due to the principle that Rav said that women are equated to men with regard to all punishments in the Torah, including those that are not equally applicable to all Jews? Now, the Gemara rejects this proof. No, that initial assumption, and we're on 85, by the way, near the top. No, that initial assumption that the daughters of priests might be obligated to avoid ritual impurity is not due to the law that Rav Yehuda said that Rav said, but rather it is something that we learn through the tradition from the words, they may not take. This phrase teaches that women are included in the marital prohibitions of the priesthood, and we might therefore have thought that they are included in all laws pertaining to priests. There are those who say a different version of this answer with regard to that verse about taking. So it was necessary for him to mention this explicitly, for it might enter your mind to say we should learn from this law, from the prohibition of impurity, and conclude. It might enter your mind to say that we should learn this law from the prohibition of impurity and conclude that just as only the male descendants of Aaron are prohibited from contracting ritual impurity, so the restrictions of marriage also apply only to men. And the verse therefore teaches us with the words, they may not take, that this is not the case. So the debate seems to be resting on the conclusion at this point that just as a male priest cannot marry a chalala, a daughter of a priest cannot marry a chalal. Now the Gemara relates, Rav Papa and Rav Huna, the son of Rav Yehoshua, arrived at the town of Hintsevu, to the place of Rav Idi bar Avin. And the town people asked them, is it prohibited for the daughters of priests who are fit to marry priests, is it prohibited for them to marry men disqualified from the priesthood or not? In other words, can the daughter of a priest marry a chalal or not? And Rav Papa said to them, you learned it in a Mishna, tractate Kedushin 69a. People of 10 types of lineages ascended from Babylonia. When the first temple was destroyed, we went into the Babylonian exile. 70 years later, the returnees came from Babylonia, and these are the people who built the second temple. When they returned from Babylonia, we have this teaching that people of 10 types of lineages were in that group. Who were they? Priests, right? Kohanim, Levium, Levites, Israelites, right? The Yisraelim, Chalalim, these disqualified priests, converts, freed slaves, Mamzerim, right? Plural of Mamzer, Gibeonites, who we've learned that these are converts who are not trusted and we're not allowed and we're not able to, no Jew can marry a Gibeonite convert. Children of unknown paternity, known as Shetukim, and foundlings. Now, with regard to priests, Levites, and Israelites, they are permitted to marry into one another's families. A priest doesn't have to marry the daughter of a priest. He can marry a Levite or he can marry a Yisrael. So priests, Levites, and Israelites can all marry each other. Levites, Israelites, and Chalalim, right, people flawed lineage, priests of flawed lineage, they can marry each other as well as converts and freed slaves. These 5 groups, Levites, Israelites, Chalalim, converts, and freed slaves, are permitted to marry one another's families, from which you see that Kohanim, priests, cannot marry halala, right? Nor can they marry converts, nor can they marry freed slaves. But Levites and Israelites can. And now the next grouping, converts, freed slaves, mamzers, Gibeonites, Shetukim, and foundlings are permitted to marry into one another's families, whereas, which is strange because the Gibeonites cannot marry, but that's a separate law that was handled somewhere else. So whereas the town of this Mishnah does not teach that the daughters of priests are permitted to marry a halal, and this must mean that they are forbidden to them. Right? Now that we've seen these groupings, the way that they're arranged, you would think that the daughters of priests are included in the first group, the Kohanim. A Kohen cannot marry a halala, and therefore it seems that the daughters of priests are included in that same group, and they cannot marry a halal. Now, Rav Huna, the son of Rav Yehoshua, said to him, "That's no proof. You haven't proved anything. For the Tan of our Mishnah teaches the law anywhere that these men may marry those women, and there is also a parallel case where these women may marry those men." Now, with regard to the case of a priest, however, since if he wants to marry a halala, this is prohibited to him, the Tana does not teach this law. Consequently, there is no proof from this Mishnah that the daughters of priests who are fit to marry priests are warned against marrying men who are disqualified from the priesthood. They came before Rav Idi bar Avin, and they told him about the question and their debate about the matter, and he said to them, "Children, this is what Rav Yehuda said that Rav said. Daughters of priests who are fit to marry priests are not warned against marrying men disqualified from the priesthood." And that is the law. The daughter of a priest may marry a man who is, the son of a priest and a divorcee, a man of flawed lineage. He's not allowed to serve as a priest, but in all other respects, he's a regular Jew, and the daughter of a priest may marry him. Now we go to a new subject. We learned in the Mishnah that secondary forbidden relatives, so we have forbidden relatives that are listed in the Torah, and so, for example, a man and his sister-in-law, right, they can never marry. She is prohibited to him, and if they do get married, it's a kind of incest, and the child would be a mamzer. Then there's the secondary relatives, who are relatives not quite as close as that first list that's delineated in the Torah, but was added to the list of prohibited relatives by rabbinic decree. So if you marry a secondary relative, you have violated a rabbinic decree, not a Torah law. And so in cases of doubt, we're lenient, whereas in cases of doubt with the Torah law, we're stringent. Here's the law. We learned in the Mishna that secondary forbidden relatives whose status is established by rabbinic law are sometimes forbidden to the husband and sometimes to the Yavam. We're back talking about Yibum. Right? A man dies childless, he leaves a brother and a widow. In some cases, that widow was prohibited to the husband. They never should have been married, but she is permitted to the brother. In other cases, she's permitted to her husband. It was a valid marriage, but she would be prohibited to the Yavam, perhaps because she has a secondary relationship with the Yavam. Now, the residents of the town of Biri inquired of Rav Sheshes, is a woman who is a secondary forbidden relative of the husband, but not a secondary forbidden relative of the Yavam, entitled to a marriage contract from the Yavam or not? She shouldn't have married her husband. He's a secondary prohibited relative, but she did. Then he died and he left a brother. The brother is not her secondary forbidden relative. They're probably half brothers, and she's related to one of them and not the other. And so the question is, because the first marriage was not actually legitimate, it violated a rabbinic decree, but okay, the guy died. Now, does the surviving brother perform yibum with her? If he does perform yibum, does he step in and provide a ketubah, a marriage contract equivalent to what his brother would have given her? But since the brother was in an illegitimate marriage, we're not sure if he ever gave her a ketubah or if it was possible for him to give her a ketubah. A ketubah delineates the rights of a woman in marriage. That's the purpose of the ketubah. It was a revolutionary institution when it came into the world by way of the Torah, that women had rights in marriage, which in the ancient world they did not have prior to that. So, is a woman who is a secondary forbidden relative of the husband, but not a secondary forbidden relative of the Yavam, entitled to a ketubah from the Yavam or not? And the Gemara clarifies the sides of this dilemma. Perhaps, since the master said that in a yibum, in levirate marriage, the payment of a marriage contract is due from the estate of the first husband, right? The brother, it wasn't like he chose this woman to marry. It wasn't his first choice. His brother died. Now this widow comes before him. He's fulfilling his obligation. And so the brother who died, if he left money, the brother who steps in to perform yibum becomes the heir of his brother who died. And what's owed to the woman in the ketubah comes from the estate of the brother who died. So since the master said that in a yibum, the payment of a marriage contract is due from the property of the first husband, and this woman, who was a secondary prohibited relative of the first husband, does not receive a marriage contract from him, since she never should have married him in the first place, so consequently, she does not have the right to a ketubah from the Yavam either. Or, perhaps, since there is a principle in levirate marriage that if she does not receive a marriage contract from the first husband, because perhaps he died penniless, then the sages instituted that she does receive a marriage contract from her second husband, from her Yavam, who performs yibum with her, and therefore she should receive a ketubah, even in this case, where the original marriage violated a rabbinic decree, but the second marriage, the yibum marriage, doesn't. So Rav Sheshes said to them, you learned it in a baraisa. Payment of her marriage contract is due from the property of her first husband, and if she was a secondary prohibited relative to her husband, she does not get a ketubah from him and not from the Yavam either. This baraisa clearly answers the question. The Gemara asks, well, can it be concluded by inference from the baraisa that there is a case of a woman in yibum who does have a marriage contract from the Yavam? And the Gemara answers, well, the baraisa is incomplete, and this is what it is teaching. Payment of her marriage contract is due from the property of her first husband. And if she does not have anything because the husband died penniless, then they instituted a marriage contract for her from the second husband, the Yavam. But if she was a secondary prohibited relative of her first husband, then she does not get a ketubah even from her Yavam. Rabbi Lazar inquired of Rabbi Yochanan, do women in cases like a widow married to a high priest, prohibited, and a divorcee or a chalutza married to a common priest, have rights to payment for their sustenance from their husbands, or do they not have a right to sustenance? They shouldn't have got married. The priest was not permitted to marry a divorcee. They did it anyway. If he's now refusing to feed her, can she go to rabbinic court and say, my husband is refusing to feed me? He's my husband. Okay, we shouldn't have got married, but we did, and now he has to feed me. Or does she not have this claim because that marriage was prohibited in the first place? Or do they not have a right to sustenance? So the Gemara asks, what are the circumstances of the case that we're talking about? If we say that she is dwelling under his roof, so he stands in a position where he is obligated to arise and divorce her. If they're living together, he has to divorce her. In such a situation, does she have a right to sustenance? It is obvious that she does not. And the Gemara clarifies, no. It is necessary to ask this question with regard to a different case, where he went overseas, and therefore he's not present to give her the divorce. Since he's not present to grant the divorce, we can't divorce them. He can't give the get, so we can't arrange for them to have a divorce. Meanwhile, this poor woman is hungry. She needs to eat. Who's going to feed her? And in the meantime, she borrowed money so that she would have what to eat, and she ate. So what is the law in that case? Can she claim that her husband's estate should pay her back the money that she borrowed so that she could eat? Is it correct to say that sustenance is a stipulation in the marriage contract? And since she has a marriage contract, he gave her a ketubah even though it was a prohibited union. And since she has a marriage contract, she also has a right to sustenance, and therefore the husband must pay her debt. Or perhaps there is a difference between the cases concerning a marriage contract, which gives her motivation to take the money and leave him. She has a ketubah. We want them to be divorced, so go. Take the money that he owes you and go. So she has the rights to it, to the payment of the ketubah, as the sages wanted to motivate her to seek a divorce. This divorcee and this priest should never have been married. Okay, they violated that prohibition. They got married. Now we want to encourage them to get a divorce. And the ketubah encourages the divorce, since she'll have a marriage settlement with which to go and live while she's waiting her next marriage. However, with regard to sustenance, we are worried that if he provides for her sustenance, perhaps she will be slow to divorce him, as she would have no reason to rush to divorce since she's being fed by him, and consequently she does not have rights to sustenance. As a matter of policy, they would say she doesn't have a right to sustenance in order to encourage her to divorce him. And he said to him, who was being asked, Rabbi Yochanan said to Rabbi Lazar, she does not have a right to sustenance because of this policy matter that we want the priest and the divorcee who married against the prohibition to divorce. Now the Gemara raises a difficulty, but isn't it taught in a baraisa that she does have a right to sustenance? And the Gemara answers, when the baraisa is taught, it is referring to sustenance that she receives after his death. At that point, she's no longer in violation of a prohibition, while the obligation to sustain her remains intact. Some say a different version of the discussion, which is that he said to him, it is taught in a baraisa that she has a right to sustenance. He replied, he stands in a position where he's obligated to arise and divorce her. He should not be required to provide for her sustenance. So the other one asked, but isn't it taught in a baraisa that she has a right to sustenance? And Rabbi Yochanan responded, when that baraisa is taught, it is referring to the period after his death. Now there's no more divorce issue that we're encouraging. They're not violating a prohibition anymore because he died. Since he was married to her, we want her to have what to eat. So then the estate will provide sustenance to her. The sages taught, a widow married to a high priest, or a divorcee or a chalutza married to a common priest, has the right to payment for her ketubah and for the produce of her property that her husband used. Excuse me. And for the produce of her property that her husband used, and sustenance. And she gets back her worn clothes and other objects that she brought to the marriage. And she is disqualified as a halala from marrying a priest, right? A divorcee who married a priest, anyway, she's disqualified, but now she's also a chalal. She can never marry a priest again. She's already a divorcee. Why would this matter? But, for example, a widow who married a high priest, right? She is permitted to a priest. She's only forbidden to a high priest. Since they went ahead and violated that prohibition, the high priest married this widow. Now she becomes a halala. We forced them to divorce, and even if she weren't a divorcee at this point, still she would be prohibited both as a divorcee and a halala. So she is disqualified as a halala from marrying a priest, and her offspring is disqualified from the priesthood as a halal. So, for example, this widow who married the high priest, they violated a prohibition. Now the high priest dies. So she's only a widow. She's never been a divorcee. So you might think that a priest could marry her. But because as a widow she married a high priest, that made her a halala. And now she's prohibited to marry any priest. So what are we saying here? So she's disqualified as a halala from marrying a priest. And her offspring is disqualified from the priesthood as a halal. And the court forces him to divorce her. A woman who is a secondary relative prohibited by rabbinic law has neither a marriage contract, nor payment for the produce of her property, nor sustenance, nor does she get back her worn clothes. And they're sort of saying that, well, this woman who's prohibited to a priest and they violated that law, we're going to force them to divorce, but we're not going to remove all her rights. Somebody who married a secondary prohibited relative, they perform the kind of incest by rabbinic decree, and so we're going to strip even more rights from her after we make them divorce. Rabbi Shimon ben Elazar said, for what reason did they say that a widow married to a high priest has a marriage contract? Maybe we don't even enforce the ketubah. Maybe because she shouldn't have married him, she doesn't get any rights under the ketubah either. Because he is disqualified from the priesthood by his marriage to her, as a priest who marries a woman forbidden to him is barred from the temple service until he divorces her and agrees not to remarry her, and she is rendered a halala and disqualified from the priesthood by her intercourse with him, and any place where he is disqualified and she is disqualified, they penalize him through the marriage contract. In other words, the sages did not exempt him from payment of the marriage contract in that case. The two of them shouldn't have had this marriage. They did enter that marriage. They're going to make him pay the ketubah, even though you might think they wouldn't allow her to receive the payment of the ketubah after that forced divorce because she shouldn't have married him in the first place. They are going to enforce the ketubah because they're further penalizing him for transgressing and marrying that woman that was prohibited to him. They penalized him. In other words, so since he's disqualified from the priesthood until he divorced her, the marriage will not last, and they did not force her to forfeit her marriage contract. And for what reason did they say that women forbidden as secondary relatives by rabbinic law, we're on 85b now, do not have a ketubah? Because he is fit for the priesthood and she is similarly fit, the couple therefore sees no need to divorce. And any place where he is fit and she is fit, they penalize her by exempting him from payment of the marriage contract in order to speed up the divorce, right? So they're going to apply the policy either as a deterrent to them entering into this prohibited marriage or to, speed up the divorce to end this prohibited marriage, depending on the situation. So Rabbi Yehuda Hanasi says a different reason for this policy. These cases, a widow married to a high priest and a divorcee married to a common priest, these are prohibited by Torah law. And Torah law does not require strengthening by means of additional enactments. But those secondary relatives, they're prohibited by rabbinic law. And rabbinic law does require strengthening. And that's why they're going to enforce, in the case of the secondary prohibited relatives, to strengthen the rabbinic decree, whereas the prohibition of a priest to marry a widow is already by Torah law, and people know that, and Torah laws don't need strengthening in that sense for people to follow them. Alternatively, the Gemara presents a second explanation. In this case, when they are both disqualified, it is he who encourages her to live with him despite the deleterious effect the prohibition will have on her and her offspring. Therefore, they penalize him by making him pay the marriage contract. But in the other case, when they both remain fit for the priesthood, despite the prohibited nature of their marriage, it is she who encourages him, and they consequently penalized her in the case of the secondary prohibited relative. She's not a divorcee, so he remains fit for the priesthood. She remains fit to marry a priest, but they did violate this prohibition, so we want to end that marriage. It's just that they didn't become a halal or halala through it. The Gemara asks, who teaches the alternative explanation? Whose opinion does it follow? Some say that Rabbi Shimon ben Elazar teaches it and is saying, what is the reason? In other words, the latter part of the Baraisa provides the rationale for the previous statement. What is the reason that they said that he is disqualified from the priesthood and she is similarly disqualified? In those cases, they penalized him through the marriage contract. It is because in such a case, he primarily encourages her to violate the prohibition, as the main disqualification concerns her, so they penalize him for enticing her to sin. And for what reason did they say that when he is fit and she is fit, they penalize her? In other words, when he married a secondary prohibited relative? It is because in such a case, she encourages him, since she is not disqualified and therefore may care less about the sin. So the sages therefore penalized her. Conversely, some say that Rabbi Yehuda Nasi is the one who teaches it. In the case of a chalutza, a woman who has undergone chalitza, who's treated like a divorcee and that she's prohibited to marry a priest, well, the case of the chalutza poses a difficulty to his opinion, as it seems to contradict his principle that rabbinic law requires strengthening. A chalutza is forbidden to a priest by rabbinic law, and yet she does have a marriage contract. If a chalutza marries a priest, then we force him to divorce, and he gives her the marriage settlement of the ketubah. So in response, he then said an additional explanation. Since he disqualifies her from the priesthood because she's now a halala by rabbinic law, in this case, it is he who encourages her. And in that case of secondary relatives, when neither of them is disqualified, it is she who encourages, and that's why we penalize her. So the Gemara asks, practically speaking, what difference is there between the explanations of Rabbi Yehuda Nasi, and Rabbi Shimon ben Elazar? What is the practical difference between them? And Rav Chisda said the practical difference between them occurs in the case of a female mamzer or a Gibeonite woman married to a Jew of unflawed lineage. According to the one who says that the reason the marriage contract is not revoked from a widow who is married to a high priest is because this relationship is prohibited by Torah law, which doesn't require strengthening. Well, this too is by Torah law. Therefore, she receives her marriage contract. But according to the one who says it is because he encourages her, and in this case, she encourages him, as the woman is disqualified regardless, and she wants to marry a Jew because there is a way for her descendants to be fit to enter the congregation, because if her mom's or son, right, she's a mom's or her son is a mom's, but if her mom's or son marries a female slave and has children, that these will be slaves who, when they are freed, are full-fledged Jews who can marry other Jews. As we saw yesterday, that's a way out for a mamzer. A mamzer can never marry a Jew, but if he marries a slave or a Gentile, the children of that union are not Jews, and they later can become Jews who can marry other Jews. Now the Gemara asks, but according to Rabbi Eliezer, who said in a Mishna in Kedushin 69a, that if a mamzer marries a female slave and they have a child, their son is both a slave and a mamzer. Since she has no hope of her descendants being fit to enter the congregation, she does not encourage him at all. Rather, Rav Yosef said the practical difference between them is with regard to one who remarries his divorcee after she has married another man. If you have a Jewish marriage and they get divorced, he can remarry her as long as she hasn't had intercourse with some other man after their divorce. She didn't go marry some other guy. If that didn't happen, they can remarry. But if she did go marry some other man in the interim, he cannot take her back. So what if he violated this prohibition and did it? So the practical difference is with regard to one who remarries his divorcee after she married another man. According to the one who says that it depends on whether the prohibition is by Torah law, this too is prohibited by Torah law. But according to the one who says it is because he encourages her to enter this prohibited union, in this case, she encourages him, as she and her children are unaffected by this marriage, and therefore we would penalize her. So the Gemara raises a difficulty. But according to Rabbi Akiva, who said that offspring from a forbidden intercourse for which one is liable for violating a prohibition is a mamzer. Right? The rabbis who disagree with Rabbi Akiva say, no, a mamzer is only the child of a prohibited union where the prohibition was incest or adultery. Rabbi Akiva had a much broader definition of a mamzer, anyone born of a prohibited union. Luckily, we don't follow that view of Rabbi Akiva. But now we're just examining Rabbi Akiva's view. So according to Rabbi Akiva, who said that the offspring of any prohibited union is a mamzer, so she does not encourage him at all, because according to this opinion, her children would be adversely affected by the marriage. Rather, Rav Papa said the practical difference between them involves a non-virgin married to a high priest. According to the one who says that it depends on whether the prohibition is by Torah law, this is by Torah law. And according to the one who says it is because he encourages her, in this case, she encourages him, as the marriage merely violates a positive mitzvah, which does not disqualify her children. And so you might think that we don't pay the ketubah. So the Gemara asks, but according to Rabbi Eliezer ben Yaakov, who said that the offspring conceived through intercourse with a priest for which one is liable for violating a positive mitzvah, the offspring of such a union is a chalal, a priest disqualified from acting as a priest. So she does not encourage him at all. Rather, Rav Ashi said the practical difference between them is with regard to the case of one who remarries his wife when there is uncertainty if she is an adulteress. If a married woman was in seclusion with another man after her husband had become suspicious and had warned her concerning that man, and the husband did not subsequently bring her to be examined by the bitter waters at the temple as a sota, right, the suspected adulteress, but rather he continued to live with her, so he has acted contrary to Torah law. If you think your wife might have cheated on you because she secluded herself with another man and you warn her, don't do that again, and she does it again just to become secluded with that other man, now you have to, when the temple is standing, take her to Jerusalem and go through the trial of the bitter waters. And until she does, this husband and wife are prohibited to each other. But if they had sex with each other despite this prohibition, they violated a Torah law. So do we force them to get divorced and we don't pay her ketubah because it was a Torah law, or we do because she encouraged him? In this case, according to the one who says that it depends on whether the prohibition is by Torah law, this too is prohibited by Torah law, so you think we don't pay the ketubah. But according to the one who says it is because he encourages her, and in this case, she encouraged him, as her children are not disqualified by such a relationship. And the Gemara asks, but according to Rabbi Matya ben Harash, who said that even if her husband went to cause her to drink the better waters, and he had intercourse with her on the way to Jerusalem, he has thereby rendered her a zona, right, a harlot, and disqualified her from ever marrying a priest. So she does not encourage him at all. Rather, Mar Bar Rav Ashi said the practical difference between these two views of when we pay and when we don't pay the ketubah, the practical difference between them is with regard to the case of a definite adulteress. In such a case, all agree that their children are not mamzers, despite the prohibition against their cohabitation. Consequently, she encouraged this sin and she doesn't get paid the ketubah. We're going to stop there. That concludes our discussion of Mishnah number 1 here in chapter 9. And we'll pick it up tomorrow, God willing, at the bottom of page 85 with Mishnah number 2 of chapter 9. Let's see if we've got any questions or comments. Okay. This is page 85. Sharon says, since one of the few rituals of the Kohanim is duchening, right? So this is, right, so Kohanim, priests, the descendants of Aaron, know who they are, right? I have a bunch of friends who are Kohens. So they no longer serve in the temple because there is no temple. But what do Kohanim do now? In Israel, this happens every day, but outside of Israel, we do this on holidays, basically. And in the middle of the service, the Kohanim, during the Musaf Amida, the additional Amida, let's say we'll be doing this on Shavuos. on Sunday morning. So during this Musaf Amida, after the repetition, and we sing the Kedusha, they will leave the room. The Levites in the room will go out with them. So I do this as a Levite. My son and I will go out. And what do? We wash the hands of the Cohens. Then we all return to the room. And when we reach the part in the Amidah, the standing prayer, where we recite the blessing of the Cohens, the Kohanic blessing. May the Lord bless you and keep you. May the Lord countenance you and be gracious to you. May the Lord favor you and grant you shalom. The Kohanim, the Cohens, will go to the front of the room. They will take their shoes off. They will have their prayer shawls over their heads. We in the congregation will have our prayer shawls over our heads. So we hear the Kohanic blessing. We don't see it. And they will bless the room. And this is known as duchening. So Sharon's question is about duchening. So is a Kohen who has married a prohibited partner, by the standards noted earlier, prohibited from duchening? I need to look up the answer to that question. I was wondering about this the other day and I forgot to look it up. I don't know. Can a Kohen who marries a divorcee still give the blessing? You would think no, because this is a Kohen acting as a Kohen in modern times, and he should be disqualified from doing the service of a Kohen. But it's different than, doing the avodah in the temple, so I'm not sure. This question could be Googled quickly. Let me know what the answer is. Larry, to be able to marry a freed slave, does the slave need to be Jewish? Yes, right? Because a Jew is only permitted to marry a Jew. So either this was a Jew who was enslaved, and then once the slavery ended because he purchased his freedom or somebody redeemed him, so now he's a freed Jew. He's a Jew in every sense. Or if it was a non-Jew who was purchased by a Jew when slavery existed, so while that slave lived in the home of the Jew, they would have to follow a bunch of laws that Jews are subject to. So it's actually, they don't need much else to become a full-fledged Jew when they emerge from that slavery. They already have the Jewish education, as it were, so then they immerse in the mikvah and they become converts. But you're right, the only kind of marriage that Judaism recognizes for Jews is when they marry other Jews. Sharon, we discussed sexual physical variations for who could perform as a priest, but is there any mention of homosexual Kohanim? I don't recall seeing that. It's very interesting. Like, are you saying that, look, the Torah is explicit, right? So if a man has homosexual sex, he's subject to the death penalty. But if he wasn't warned that he would have the death penalty if he did it and then did it right away, the court isn't actually going to execute him. So I think what you're asking is, if you have a known homosexual who is a priest, is that considered a blemish that would render him prohibited to act as a priest, or not, because it's not some kind of a physical blemish on his body? So the fact that he committed what the Torah regards as a crime, does that mean he can no longer serve as a priest? I don't know the answer to that question. That's another one that we need to look up. Okay, that's what I've got for us today. With God's help, we'll be together again tomorrow when we'll do page 86. So we'll be starting at the bottom of 85. Have a great night. And if it's still daytime where you are, a good Hodesh, a Hodesh Tov, as we welcome